Welcome to the latest edition of Spotlight at Northern. I'm John Schaaf, Professor of Political Science at Northern State University. That's Ken Blanchard, he is too. And our guest today is the inestimable Brian Bengs, Professor of Criminal Justice here at Cruise Ship Northern. And a few weeks ago, for Constitution Day, so I guess about a month ago now, wasn't it? We did a noon forum, we meaning this motley crew right here, did a noon forum over in our library about, what did we call that? It was Why My Constitution Can Beat Up Your Constitution, I think is what we called that. And we talked a little bit, this is in the heart of the Kavanaugh hearings, which took sort of a turn after our noon forum, turned largely for the worse as America collectively threw up. But we were talking about the role of the Supreme Court in constitutional interpretation. We sort of want to recapitulate that and more today. So, Brian's background is in law, correct?
Yes.
He's our resident lawyer. No one throws stones. You got a favorite lawyer joke?
No, well, there's so many to pick from.
Yeah.
Can't really just pick just one.
Yes, yeah, I got it. I'll try to think of one. In fact, I have relations in Boise. There's actually a bar that's called No Lawyers. That's the name of the bar, and they don't allow lawyers in the bar.
Really? They card you?
I don't know how they find out, but if it slips, right? They ask you if you need a writ of mandamus, and then if you know what they're talking about, they kick you out. Anyhow, to tell you, because really your career up until just a handful of years ago when you came here to Northern was a military career. So, I'll tell you. So, where you're from, where you went to college, how you got into the military thing, what you did with that.
Okay. I'm originally from North Iowa, small town in North Iowa. So I grew up, we'll call it Southeast River.
Mm-hmm.
A little bit
Gotcha.
little further than here.
Yep.
And when I graduated from high school, I didn't know what I wanted to do when I grew up. So I thought, go to the Navy, and spent 2 years on active duty with the Navy. Realized that was not what I wanted to do when I grew up. So I left there, and I had the GI Bill, and they gave me a GI Bill kicker beyond that. So I started out and went to Iowa State for a degree in history. Still not knowing what I wanted to do when I grew up. I thought, graduate school, law school, and kind of did a coin toss, applied to both, and figured, well, if I get into law school, I'll go there. Got into the University of Iowa, went to law school, and then was getting closer to graduation and thinking, well, what should I do now? Because I'm kind of have to grow up.
Yeah.
And I was looking for county prosecutor jobs and found that they did not pay anything reasonable. I had more student loans than they paid per year.
Yep.
So I looked back at the military and decided, well, I can do 4 years and get out and have a pretty good idea what to do then. Mm-hmm. And then joined the Air Force, and 4 years turned into 19 years and multiple other degrees beyond that. The curse of the Air Force, thank you, Uncle Sam. Yeah. And teaching opportunities and going all around the world and doing fun stuff. And then it was time to leave, and I came here.
So what were the kinds of things when you were in the military? I know you wore various hats, literally and figuratively, I suppose. But what kinds of things did they have you doing? Because you had your law degree when you went into the Air Force, and so what was your job title?
Okay, so
I guess you probably had various titles, but
so every lawyer in the Air Force, lawyer in the military in general, is called a JAG, a Judge Advocate General. So everybody's part of a Judge Advocate General Corps in their respective branch. And when I first started, I was brought up assigned to my base, and I was given the title Chief of Civil Law. Mm-hmm. So basically, anything that didn't fall into one of the titles would come to me. So, somebody wants to do a base organization, they want to set something up, or they want to do fundraising as a base organization. So they want to use borrow something that the government has, a tent or something like that. Mm-hmm. Can they do that? So that would all come through me. And then I was made the Chief of Military Justice. So if anybody got in trouble for any reason, I would consult with the investigators and then work with the trial counsel to develop the charges that would go forward and just oversee the administrative aspect of getting the court martial set up and all the moving parts ready to go, and then doing the trial and making sure that the individuals...
Were you prosecuting, or were you more organizing, shall I say?
Well, as the Chief of Military Justice, you organize, but you also prosecute.
Okay.
You can get the cherry pick the cases that hey, this is the most interesting one, so I'll assign that to me to do.
Gotcha.
So I did that, and I was prosecutor variously for a lot of my time. But the military is good and bad, I guess, in the sense that the longer you're in, the less you get to do stuff like that.
Yeah.
So after my first base, I went to another base, the B-2 base in Missouri, and was the defense counsel for that base. And anybody who got in trouble there would come see me, and I would see if I could get them off or get them a less punishment.
Yep.
And then I went to Japan and did contract law there. So federal government contract law and fiscal law, which is not particularly exciting, but in hindsight, it's good to know.
Yeah.
And then went to another base and started doing oversight of other bases, their efforts to do military discipline and that sort of thing. And then the Air Force picked me for a graduate program to go back to George Washington University for advanced degree in international law with a follow-on assignment to teach that at the Air Force Academy.
Yep.
And then after that, I went to the Air Force Warfare Center, where I was the #2 person in the office. So I basically managed the affairs of the office and the personnel.
Gotcha.
And then went to teach at the NATO school, where I got to teach international law and operational law to people from a whole bunch of different places.
Yeah. And some of that is what you do here as well. You've taught some
so that is one
human
of the
rights, international law, that sort of thing is
one
part
of
of what you teach here.
Perks of my job is that I get to you guys let me, so thank you for that.
Yeah.
Let me teach topics that are related to, or in many cases the same as the stuff that I got to work on when I was on active duty, so stuff that I'm familiar with.
Yeah, I find that interesting because normally, I guess around here, most lawyers have to practice various kinds of law just because our firms are not huge. It's not like they're 20-person firms or 50-person firms where a lawyer is doing like one thing.
Yeah.
Although they're, some are more specialized, but they're not super specialized, which sounds like they had you, because I would think contract law versus prosecution, on the spectrum of the law, those are relatively far apart.
Yeah.
So it's, do they take into account this is what you do well, or this is what you're interested in as they give you your assignments? Or so we need a contract guy in Japan, so you're
assuming he does something well.
Yes.
Well, that's true. But I've got promoted enough, so I convinced somebody that I did something well.
Yeah.
But by and large, you're expected to just be exposed. To be a leader, they want you to be, not necessarily an expert on one particular thing, but to have a little bit of knowledge about a lot of different things. So
Gotcha.
You should have done contracts, you should have done fiscal law, maybe labor law, environmental law. Certainly military justice. If you haven't done that, you're not going to go very far. So that's one of the keys. But yeah, they want you to do a lot of different things, at least for a little while, so you can be competent when you go, oh yeah, that's what's happening.
Gotcha.
Sounds like in many ways an ideal sort of prep for being a college professor. Is this, by the way, what you're doing now that you've grown up, or are we still waiting?
This is, yes.
Okay.
I'm pretty happy doing this, a lot of fun.
And you are grown up? Have we decided that yet?
I don't know if I can really argue against that too much anymore.
Yes. There are certain telltale
my
signs.
hair has gone way.
Somewhere along the line it goes out. Well, your experience in military law, did it have an effect on your view of the law that you might not have gotten from other kinds of law?
One of the things I think that my background, and every military lawyer's background is going to be, is that we're trained and expected to. I wasn't working for like the base commander. I was advising the base commander, but that's not my client. My client was the Air Force. So my client was the system. And you always had to look at things when you're looking at it from like, does this help the system? Is the system following the rules? Does this benefit the system? Does this not benefit the system? So my perspective at looking at things is from a step back approach of, is everything working the way it's supposed to? And if this happens, will the system suffer for it? Which, near as I can tell, my students are, this is what I'm talking about with them, is like, I ask them this all the time, how does the system benefit? And it seems to be perhaps somewhat unique in that regard that, the politicians that we're talking about don't really seem to, at least in my mind, seem to consider the system so much as, well, what's good for my group that's operating within this system.
Right.
That makes sense.
That does make sense.
We should probably get on to the actual subject of the day, which is supposed to be the U.S. Constitution. So you gave a very nice presentation at our Constitution Day thing over at the library. See, I think he's competent at least in one thing. Nice PowerPoints.
Well, if you're in the military, that's kind of, I'm a PowerPoint ranger, so.
Yes. Do you have like a patch for that?
Well, I've got a meme for the patch of that.
Yes.
Actually, give me one.
Yeah, gotcha. But what you did is you went through various different theories of interpreting the Constitution. We don't have time to go through all those. But if you want to pick 2 or 3 of those that you think are probably the most prevalent amongst those who are in the field of practicing or teaching of constitutional law? If one, run through those real quick.
Okay. Well, I think probably the most prevalent is going to be textualism, and then I like to set up the straw man of originalism because I disagree with it, and then
we'll get to that.
Maybe pragmatism as something a little bit different. So textualism is based upon the idea that you can read something. Obviously, somebody wrote it down at some point, and you read it, and it conveys the ideas that they were trying to express because they went to the trouble of drafting it carefully. If it's a product of the legislative process, they've spent a lot of time arguing over this word or that word. Or if it's the Constitution in this particular case, they spent a lot of time debating, should we have this in there, should we not? Okay, what should it say? So if we read the text, we read it and go, oh, that's what it means. And then we stop. We don't look for other sources to go, well, what does it mean then necessarily? We just try to read it and go, okay, I can clearly see what they meant, and that's what it is. And then that's what you would interpret and apply. In the context of the originalism, it's similar, except they're going to start at the text again, and then they're going to go, all right, this was written in 1787, and what did it mean then? What did it mean to the drafters is one context in the original understanding. When they were writing this, what did they think? But in the context of the Constitution, you don't really worry about what did the drafters think, original understanding. It's what the people that ratified it understood it to be. So they're secondary already because they didn't write it. So they were given it and said, well, this is what it means. And they're going, well, okay, this is what I think it means as based upon my reading at the time. And so the original understanding, what did I say? Original understanding of the ratification conventions and the people at that time. And the other approach you could have to originalism would be the original meaning, where the government obviously has operated under the Constitution for quite a while now. So how was it interpreted and applied, in the 1790s and the early 1800s up to a certain point?
Are you talking there about precedent?
Historical precedent, yeah. So you can still kind of wrap that into originalism. From the pragmatism standpoint, we're still going to start with the text, and then we're going to step back and go, all right, I know it says that, but what do we, how could I interpret this different ways? And which one would produce the outcome, considering the political and economic consequences, which one's going to produce the optimal outcome for society? So they're functioning in that regard kind of as a legislative body to consider and make what they believe to be the best decision for society when they interpret the Constitution in that regard, which is obviously going to be criticized because it is by default an activist take on it, whereas originalism claims that it's immune from this activism because they're only understanding what the original ratification was.
And so you express forthrightly your disagreement with originalism in one paragraph. So I'll give you more than one line. One paragraph, maybe two paragraphs. What's your beef with originalism? Then you get to go and why you think originalism
No, I'm
rocks.
not going to defend originalism, but I can say some things about it. But
Go ahead.
Well, originalism, from the theoretical standpoint of originalism, if it was possible to do what they say, I would say yes, absolutely. That is, why should anybody be anything else? That is a huge amount of intellectual appeal. My biggest problem is the practical aspect of it. You can't do it. Scholars today cannot agree on, well, what does this mean? What does it mean? So we've got judges acting as historians when the historians themselves can't figure out exactly. There's going to be a debate ongoing about this. So it gives the judges the opportunity to decide for themselves, basically a pragmatic approach of, I like this one, not that one. So we're going to go with this. Even though there's ongoing debate about it, we'll just go with this because I have the power to decide.
So would it be fair to say that your view is that in practice, originalism is pragmatism in sheep's clothing?
In disguise.
Yeah, in disguise.
It allows retroactivism, as I call it.
Yeah.
Which
is a cool phrase.
Yeah.
I like that phrase. I like retroactivism.
like that. That's pretty good.
Well, you don't want to. What do you want to defend? Because I know you disagree with him. Because I was in the room in the library when you guys had this.
I suspect we probably agree on a lot more than we disagree on here. But I agree that there's some problems with originalism. It's not clear to me that they're all that difficult. When the Constitution says each state gets 2 senators, that still means 2, and there's those sorts of things. And I think that when it comes to something like freedom of speech, we can do a pretty good job of figuring out what the original contract meant. What concerns me is if is the Constitution a contract? That certainly has been, I think, the greatest argument for its authority. The reason we should obey the Constitution is because we've all agreed to obey it. We have, in effect, implicitly or explicitly signed on. Then the question becomes, how do we read that contract in a way that limits both sides, produces obligations and rights for both sides? The problem I see with the pragmatic argument is, why do you need a constitution in the first place? Why don't you just get 9 old people the power to write anything into the original document they want?
Yeah, well, it's a fair point in the sense that the Constitution, under the pragmatism theory, isn't married to a particular time, and it's going to have a meaning or interpretation that evolves over time with society. So some contexts, they would say, hey, that's a good thing. We don't want to be married to this 18th century ideals, these principles, when we are clearly a different society today than we were back then. We're still guided by the same ideas, so it gives more freedom to, have the government be more effective than say, you know what, we're stuck in time. But yeah, your point is fair in the sense that they're kind of acting as legislators then.
So it seems like there's a kind of a meta discussion that we're alluding to but not quite stating plainly, which is when you were talking about pragmatism, you used a buzzword, activist. And so when people talk about the Supreme Court, they generally like to talk about 2 camps, judicial restraint, judicial activist. Few people admit to being judicial activists, which might say something about judicial activism, is that everybody, at least, Justice Kagan famously said, we're all textualists now. No one wants to at least admit in public that they're a pragmatist or that they're an activist. But then these terms, and here's my little textbook definition of each of those terms, is everybody recognizes, I think, that we don't necessarily want to be tied to late 18th century interpretations or whatever the date of a particular amendment is. We don't necessarily want to be tied to that era's interpretation of what those words mean. The question is, who's the legitimate organ of social change? And so people who believe in judicial restraint, who often are tied to some sort of textualist, originalist viewpoint, at least those who scream loudest about judicial restraint, tend to say that the ambiguities, the necessary ambiguities in any constitution or any contract should be interpreted narrowly because of all sorts of institutional reasons. The Supreme Court is a bad institution for social change. If you want change, the Constitution anticipates this by having processes, whether it's a legislative process, whether it's federalism, or whether it is the amending process. This is how you keep the Constitution up to date. Whereas people who believe in judicial activism, especially those, again, I think on the court, Justice Breyer has been the most vocal on this. He's written a couple books defending this concept of the so-called living constitution, is precisely that the meaning of the words in the Constitution evolve over time. And so we would have to interpret even something like, say, equal protection in light of what do we think about equality, not necessarily what did they mean when they wrote the Fifth Amendment or the 14th Amendment. What do we mean today by equal protection? Or even our standards on speech have changed quite radically since, say, 1800. Well, so then it's the job of the court to keep the law up to date. And so how does one of those seem more legitimate or not? Or how does that work with Kent's point, is that if it's the job of the court to keep things up to date, why don't we just elect a Supreme Court? Why would we have a Supreme Court if they're the ones who keep the law up to date as opposed to these various processes that the Constitution anticipates?
Obviously, the legislature should be the one that updates the laws, but you obviously can't update the Constitution at the drop of a hat. We have 27 amendments because it's not easy to do.
Yeah.
And it has to be
And we
massive
might ask
consensus.
why that's the case.
Why it's not easy to do?
Yeah, because I suspect that was on purpose.
Well, yeah,
Yes.
that's true. So now, I think we're in agreement on this, that
Yeah.
the legislature should be doing this, but it can't do certain things if the court. So basically, do we want the court to be leaning ahead, or do we want the court to be pulling the reins back when the legislature tries to do this?
And so, while because there's a school of thought, what you're saying, what it triggered in my head was that there's famous law school dean, which is sort of like being a famous bassoon player, but nonetheless, I mean, the most famous bassoon player in the world, nobody knows who he is, but
But he was a maestro.
yes, but this famous law school dean from Stanford, John Hart Ely, who wrote a book in the early 80s, I think it was, called, oh crud, this is what I get for not looking it up, Democracy and Dissent or something like that. Now I can't remember the name of it, but John Hart Ely. And his argument was, this is written in the, like, around 1980, after kind of 20 years of a relatively activist court, probably 25 years of relatively activist court with a lot of social change coming from the court. And Ely, while being politically, it seems, disposed to like the policy outcomes of many of those decisions, didn't like the court as the institution. His argument was that if the court was going to be activist, what it should be activist in is expanding democracy as much as possible. So, for example, he was a big fan of the Baker versus Carr and those reapportionment decisions and the voting decisions of the 1960s, which made our democracy more egalitarian and more open. And so participation was a big deal to him, precisely so legislatures could be the ordinary instrument of social change instead of courts. So like Ely famously, despite liking the policy outcome of Roe v. Wade, disliked that because it stopped what was a democratic process with insufficient textual grounds to do so. So that was a debate the country was having, and that should have been allowed to play out. And the court's role was to make sure that there was as much democratic participation in that debate as it could. That was more of a statement than a question.
No, but I agree. I concur entirely.
Well, on that note, it's been nice talking to you. We're supposed to be arguing here.
Okay, well, we're in violent agreement, I guess.
Yes. Dang it.
I wonder if it's as, I mean, it sounds like you're saying that the originalists are just as activist as the activists.
Yeah, that is essentially my concern, is that originalism is an excuse to be activist, but say that you're not.
But I mean, I wonder if that's true. For example, I know exactly what Harry Blackmun thought about abortion. He thought it was a very important right that women should have. I don't know what Antonin Scalia thinks about abortion, and I've read everything he's written on it. I know exactly what he thinks about the constitutionality of abortion, but does he think it's a sin? Does he think it's wrong? Does he think we ought to have legal abortion? I don't know those things from his writing. Could you imagine that Scalia is going to turn, if he'd had a majority in the court, would he have turned around and said, abortion is a violation of equal protection, so it has to be illegal everywhere? I mean, there is that difference, isn't there, between the people who call themselves originalist, or Scalia didn't, but we'll just say the conservative side of the judicial spectrum, and the other side, which was willing to create what looks like the creation of brand new rights, like the right to gay marriage. I mean, there is that difference between the two sides, isn't there?
Well, creation of rights, or just recognition of rights. Because creation of rights implies that they created out of whole cloth. But
didn't they?
As we had the discussion before, the Ninth Amendment would say that there's a lot of rights that, even if they're not listed in the Constitution, you still have.
Right, but that doesn't tell you which those rights are. And
True.
so if you look to the Ninth Amendment, then you can simply throw into the Constitution anything you want to protect. I happen to be in favor of legal same-sex marriage. I just don't see anywhere in the Constitution that is identified as a basic principle. And when you look at Kennedy's argument in the case, basically just says, well, I think that people ought to have this. So if that's your view of what the court is, doesn't it, here's my question, I suppose, is as soon as you get a conservative majority on the court, are you going to continue to saying the same things you're saying now? Are you suddenly going to discover that the Constitution is much more limiting than you thought it was in the first place?
Well, obviously there's a conservative majority on the court now.
We don't know that yet. It's very probable.
Okay.
But go ahead.
I think it seems a safe bet. I would take the bet.
It's likely.
Yeah. Yep. So I'm of the opinion that Roe versus Wade will probably be overturned in the next 5 or so years, maybe sooner. I had this discussion in class yesterday with some students about, okay, here's the background. Here's what's probably going to happen. What's going to go away. What is the secondary effects to this when this goes away? I am of the opinion, and you mentioned it before, that the court itself should not be, at least the Supreme Court, life tenure. I would support a limited term of 10 years, 12 years, whatever, of whoever's the president. Okay, you appoint them if the Senate concurs, and that person's got 10, 12 years, and then they're gone, and they ride off into the sunset. We get more flow through the court, and the court is what it is. So people are going to interpret, this is why we have the fights about picking the justices. Should they interpret it one way or the other? I obviously have an opinion on that. I'm kind of drawn towards pragmatism because it produces an outcome that the legislature, particularly now, isn't going to produce given the gridlock that we have. So I like when something decisive happens, but it's a tough intellectual problem here in the sense of I think democracy is the answer. Yeah. It should be the answer. It should always be the answer rather than the court. But if the legislature is not functioning like it should, who's going to do it? Well, somebody should be doing it.
Well, there's an assumption built in there that the legislature is not acting like it should. Well, what should the legislature act like is the question.
And then to me that addresses...
If I've said it once, I've said it 10,000 times to my American government students. According to the American founders, on the whole, the problem of democracy is not that it acts too slowly, but that it acts too quickly. And surely, even though when defending executive power in Federalist number 70, Hamilton says promptitude of action is more a vice than a virtue in a legislature. But that is what you want out of an executive. You do want promptitude of action, which is what Federalist 70 is all about. And you see this, I think, in spades in Federalist number 62 when Madison's talking about the U.S. Senate, that it's clear that when he rails against the evils created by voluminous and malleable legislation, when there's a lot of legislation and it's always changing, this is a threat to the rights of the people. And so you're expressing, and this is exactly, it's interesting because this is exactly what, if you pick up Woodrow Wilson's book, the Constitutional Government in the United States, his second book, where he talks about the living Constitution, it was clear that Wilson shared your view, which is that Wilson, who had a principled disagreement with separation of powers, he said that no good government was ever made based on antagonisms. He didn't like separation of powers and liked decisive government. And part of the reason, I think the intellectual reason for enunciating this idea, the concept of the living Constitution, is precisely to undermine the founding political science that says that democracy is good within a process. And so we want change within a process. And the reason the constitutional order is set up so that when there is change, especially when there is significant change, radical change, decisive change, it must be done based on consensus. And the reason our legislature doesn't work today is because we have no consensus. The American people do not have a consensus about much, and therefore probably the legislature shouldn't be doing anything. because whatever it does is going to annoy a significant portion of the population. But I think you're on something, is that if activity in government is what you want, then it seemed like a living constitution and a more activist Supreme Court, because they don't have the checks that other bodies have and have. I mean, their power is basically undefined in a lot of ways in the Constitution. Certainly not like the legislature, which is confined to powers herein granted, as it says in Article 1, Section 1. There's nothing like that for the legislature. But anyway, again, I've given yet another speech.
Well, let me jump back in and say, just to rail on originalism again.
All right, go.
So one of the biggest problems I have with originalism is the fact that they are reviewing laws, judicial review, and saying things are unconstitutional because it's not, original understanding or something like that. But they're using a power that, correct me if I'm wrong, is not written in the Constitution. So if you were an originalist looking to find the ability for judicial review, you would not find it.
Well, I think it's obviously anticipated. It's in the nature of the thing.
It's anticipated, but it's not written.
It's in the nature of the thing. Well, much like.
So the founders made a mistake, and
no, but you could easily say this. It's much like executive privilege is not in the Constitution, but it's understood to be the nature of the power. And so judicial review is not in the Constitution, but it's understood to be the nature of the power, which is why it doesn't take long. It took a handful of months for Alexander Hamilton to articulate judicial review.
Wasn't it articulated? Wasn't it discussed at the Constitutional Convention and for some reason not included?
I don't know.
I think it was.
It was discussed briefly, but the primary foundation for the idea of judicial review is in Hamilton's comment in Federalist 78.
As a concept, absolutely. I think they need that.
But for an originalist, that's pretty easy. I mean, you can figure out what you think the founders had in mind by looking to see what the founders wrote apart from the Constitution. But I think I agree with you to a large degree on the notion of originalism, and the problem, of course, is that in the really interesting questions, it's often hard to know what they would do about modern problems. So we have to come up with something like that. But maybe it would help to look at some specific issues. The death penalty is a good example. I mean, the attraction of the idea of the living Constitution to people like Justice Brennan surely was simply this, that they were not going to get the abolition of the death penalty out of any legislature. So this was simply a way of overriding democracy and getting these guys to write their own view in. If Brennan had a majority, the death penalty would have been declared unconstitutional. Is that something justices should be doing? Is the death penalty unconstitutional?
Well, clearly not. At the founding, if we go back to originalism, at the founding it was contemplated, and much worse than what we do today was contemplated as, that's just.
What do you think? I mean, would you, if you've now been appointed to the United States Supreme Court.
What's scary about that is it's by President Blanchard.
Yes.
Congratulations on your election.
Yes, thank you. Congratulations on your
Senator Schaaf
I made it through the Senate, so yay.
I mean, should the judges, I don't know what your opinion on the death penalty is, but should the judges make that decision based on whether they think it's a good idea or not?
Well, they are unelected, so I genuinely do believe democracy is the better answer for this, but obviously, many states are not going to agree with this. Federalism is going to have to be the answer, should be the answer, in the sense that if a state wants to not have it, they cannot have it. If a state wants to have it, as we have now, they can have it.
So you think the better way to work it out is to let the states do this? Of course, but somebody like Brennan, who thinks that this is a violation of fundamental human dignity, is trying to get the court simply to declare that it is unconstitutional. Suppose he'd had one more vote and been able to do that. Is that what the court should be doing? I mean, should he have done that, or should one say, okay, if the American people want it, if there's clearly no consensus that the death penalty is unconstitutional, then we'll just have to wait till they come around. I mean, what should the judges do in that case?
Well, the better way is obviously to go through the people and work through the legislature in that way. That's the much slower way, and often cases the non-effective way. So to the extent, if you believe it's a moral wrong, it's a tough call.
I think the more principled argument for Brennan's point of view, and you can make this, but all the hot button issues, whether it's abortion with Roe v. Wade or the Obergefell decision with same-sex marriage, is that again there's the ordinary way in which you get social change, right, and that is through democracy, right. You could argue that there are certain areas of the law or certain areas of policy. We use the phrase fundamental rights, right? That's something that people who are on the pragmatist, activist, whatever you want to call it side, tend to use that phrase, certain fundamental rights. And on those fundamental rights, democracy should not rule. But of course, then the argument becomes, what's a fundamental right? And who decides what a fundamental right is? And this, again, is part of the disagreement, it seems, between more, I'll call it originalist, textualist, restraintist, whatever you want to call them, and the activist, living constitutionalist type folks, is precisely how much leeway does the Constitution give courts to enunciate what you said before, I think you used the phrase new rights, right? Or are you recognizing
rights, yeah,
old rights? And so I think that's part of the disagreement, is who says what these new rights are. And so Hamilton in 78, I think, takes a more restraintist point of view when he says, because he talks about this awesome power of judicial restraint. And he says, well, how could we justify this power, right? Because anti-federalists were saying this makes the Supreme Court the ultimate power. If they get to decide what the Constitution means, the Supreme Court, then they're the ultimate power. And so Hamilton has to assuage people's concern about the court. And his phrase that he uses in 78 is, the court should limit itself by strict rules and precedent. Strict rules and precedent. And so, which my interpretation of that is it something that is explicitly listed in the Constitution, or relatively explicitly listed, that would be something fundamental, or something that has a very strong grounding in the legal traditions of the people, right? So you'd look to the common law and the history of common law and long precedent, and is this something that is within our traditions but was not articulated? And that's actually what I think what they mean in the Ninth Amendment about there are other rights, there are other traditions within our legal system that we did not articulate in this, to make it workable, for one thing. We did not articulate. That doesn't mean they don't exist. So to keep the court from being arbitrary and by simply inventing new rights, if there are these rights that aren't articulated, as it says in the Ninth Amendment, and the court can enforce those rights, they could say anything is a right. At which point you no longer have limited government.
Anything that they like.
Yeah.
Well, a right is limited to government, though. The more rights that I have, the more limited the government's opportunity. So the less rights I have, the more authority the government has over me. So if we're going to err on the side of more rights than on the side of less rights.
But if you can decide arbitrarily which rights you're going to recognize, then government is not limited if it can decide, if any part of it can decide simply on a whim, this is what a right is. Because a court that can recognize abortion as a right when there's no constitutional ground for it can just as easily turn around and say abortion is now everywhere illegal. It can just as easily say that African Americans cannot be citizens since they were once slaves, as the court famously did in Dred Scott. But I wonder, it does look like we're getting a sort of sea change among a lot of liberal academics and perhaps some politicians on the question of the court, now that it looks like there is a conservative majority on the court, we were both discussing a piece, I haven't read it, but I sort of got the gist of it, that we simply ought to, as soon as Democrats have the power, they simply ought to pack the court with more judges. The problem with that is fairly obvious, because the Democrats are not likely to always have a majority. And then we're going to end up with a 435 seat Supreme Court. I just wonder what your take is on those sorts of options. I've seen the court, the very idea of the Supreme Court attacked from the left in ways that I've never seen before. I don't know. What do you?
I think at the core of this is the legitimacy issue of the court. Now, the court, although nothing has happened that anybody should be particularly objected to at this point, they're anticipating it. So it's kind of like the eve of the Civil War in the sense that we anticipate Lincoln's going to go ahead and outlaw slavery, so we'll just act now. So these ideas are being floated in that context, I think. But the legitimacy of the court is in peril, I think, given the nature of the various interpretive methods and people being selected not because they are qualified, but because, wink, wink, nod, nod, we know that how you're going to rule on these things. You won't tell us, but we can kind of predict how you're going to rule. So we're picking you for the political decisions that the court is going to make, expecting you to include this retroactivism, as I said, as a justification. So the court is being undermined by the explicit partisanship in picking justices. And the packing of the court, is that a good idea? Well, it's an effective idea. Is it a good idea for the system? Absolutely not, as you pointed out. So when we're going down this path, somebody needs to be looking out for the system and the system and the system, not just for, he'll pick what we want. He'll do what we want because this is what we want and that's what they want, and so we need to force it down on them.
Yeah, I would have said much the same thing myself.
Would you guys stop agreeing?
What I'm trying to figure out, though, is it seems to me that pragmatism, as you describe it, invites precisely that sort of thing. Because if we're going to take a pragmatic view of the Constitution, in other words, let's interpret it in a way that makes society better, then the court becomes a very powerful institution in both generating social change and preserving it. And once you get to there, then it becomes a life or death matter whether you get your guy on the Supreme Court or not, or whether you're going to turn it around. I mean, that's one of the things I think that I find most disturbing about a decision like Roe v. Wade, apart from whether you think abortion should be a right or not, is once the court had made that decision, then it depends entirely on 5 out of 9 justices. Wouldn't it be better for the court simply to say, okay, let the legislatures fight this out, whether there's gay marriage, for example? I suspect we were moving toward that. We're probably moving toward that. So why does the court have to come out and say, okay, then we're going to just settle the matter right now? There is a right to gay marriage. Doesn't that precisely create the situation which you seem to find deplorable?
Mm-hmm. And I won't say I agree, but I'll just wink and say. But yeah, the big battle over the court, the Kavanaugh and the Gorsuch appointment, was to defend what had already been achieved in the 60s and early 70s for these things that were, if you're an originalist, you're not going to agree with them. You're not going to support them. Miranda rights? What? No. So that was pulled out of whole cloth as well. So
yes,
if this idea, if these things that we've just kind of become accustomed to as basic rights, even though they're not explicitly listed in the Constitution, are going to be imperiled by these judges, then it does make it an existential fight of, you're going to change what we've become accustomed to, and we have to defend it at any cost. So, yeah,
it strikes me as a kind of bait and switch. There was a really interesting this summer, article in the New York Times. It was after there was a series of rulings at the end of the Supreme Court's term in June, that were kind of pro-free speech / religious liberty cases. There was the cake maker in Colorado case. There was the one about the labor union one out of, I think, at Illinois, one where you didn't have to pay the dues to the union if you didn't want to. Then there was one out of California, the one where the pro-life abortion, pro-life pregnancy center was forced to have a sign up advertising where you could procure abortion services. And in each of those cases, the court sided on what we would call politically the conservative side on free speech grounds in all cases. And Justice Kagan, in one of her opinions, I can't remember which one now, dissenting in one of these cases, said that the First Amendment was being weaponized. They're weaponizing the First Amendment, meaning they're using the First Amendment to get policy positions she doesn't like. And so the New York Times did this article about this, and that was in the title, Weaponizing the First Amendment. And you had all these law professors on their, they went, especially, older law professors who, were champions of free speech and freedom of conscience in the 1960s and 70s. And they all said, well, golly, if we knew conservatives were going to take advantage of this stuff, we would have never advocated for this. Which I thought, well, that sort of just gives away the game, doesn't it? You don't really have a principled belief in free speech. You believe in free speech for your side, and if other people get free speech, they should shut up, right? You don't really believe in religious liberty. When it was kind of cute, cuddly religious minorities that you didn't perceive as any sort of threat, that and were not part of the American majority, then you were for religious liberty. But if other people if people you don't like are going to get religious liberty, well, then that's weaponizing the First Amendment. So in that sense, precisely what you're saying seems to be the case, is that we made all these policy victories in the 60s and 70s, and probably into the 80s slightly. But now we want to freeze that, right, in stone, and we now declare any argument against this unprincipled. But what's really happening is I think they're sort of admitting, well, we actually have no principles. What we really like is policy outcomes, and we don't really have a principled belief in the First Amendment. The First Amendment is a weapon for us to use to achieve power over people we don't like. And when it ceases to serve that purpose, we no longer believe in the First Amendment. Witness when Nadine Strohstein, the former head of ACLU, went and spoke at William and Mary College last year. And what she was shouted down with the phrase, free speech is hate speech. Right? And that's not an unpopular view in legal and university circles right now. Free speech that's just a phrase the powerful use to shut up unpopular minorities. So free speech is actually hate speech when it's being used by the wrong people. And so it just seems like what's happening is we use the Supreme Court's power to achieve policy victories without any principle behind them. And we're afraid that other people might do the exact same thing. In which case, I think is what Ken is saying, well, then this exposes the raw underbelly of pragmatism or activism. And if we want to maintain the legitimacy of the court probably would have maintained its legitimacy better if it had been more restrained in the use of that power and only declared things unconstitutional when there was a clear violation of the text of the Constitution or the legal traditions of our people, or declared rights that had clear textual basis to them or a clear tradition. And again, whatever you can say about same-sex marriage, it's not in the Constitution. And the legal traditions of our people are entirely in the opposite direction.
I want to find out whether Jehovah's Witnesses are really cuddly or not. But go ahead.
Isn't this a...
Yes, because they're not a threat from the point of view of some people. Because they're not really a threat to the secular order. It's okay to accept Jehovah's Witness, but an evangelical baker in Colorado is perceived as a threat. He's got the wrong views, and so he has to be limited.
I want to hear what he has to say.
Well, I agree. Unprincipled principles should be principles. They shouldn't be principles for you and then not for you. So I'm entirely in agreement with that
Yeah.
for consistency, for the sake of consistency. But this is the Supreme Court is kind of forced into this role by the essence of federalism and the requirement that if one state does something, like we want to recognize gay marriage, which means, hey, everybody else, guess what? The Constitution requires you to recognize our gay marriage. You don't have to do it yourself, but you have to recognize here. So if everybody decides from your state to come here and get gay married and then go home, you're going to have to act. So,
but they don't, because that's defined by full faith and credit clause, and that full faith and credit is it says in Article 4, Section 1, as defined by Congress, which is why when Congress passed the Defense of Marriage Act, they defined in federal law, marriage is between a man and a woman. Therefore, you did not have to recognize same-sex marriages from other states.
They acted in response.
Yes.
Right.
So, that's the appropriate response. Whether you would like the policy or not, so Congress could have made policy or not, there was a legislative solution to the problem. But then, of course, the Supreme Court declared the Defense of Marriage Act unconstitutional, which was, of course, the setup where everybody saw this coming at that point, that Obergefell was coming. But there was a move for greater acceptance of same-sex marriage, even though for a good decade, every time same-sex marriage came up, either as a state constitutional amendment or in a state legislature, a referendum on a vote, every single time it was voted down. But then there started to be, probably starting around 2010, there started to be victories. Or when so-called traditional marriage was put on the ballot, that lost. And you could see that the tide was starting to turn. And again, this is where the court gets into trouble, is why not just let that tide go and see where it goes? And I suspect with Ken that as we sit here in 2018, 75% of America would have been same-sex marriage. And those states that did not recognize same-sex marriage would be a minority, and there probably would be federal legislation on the way to effectively, we would have repealed Defense of Marriage Act in a legislative way instead of through
that would have been the optimal solution.
Through
the
court fiat.
You don't think the court, kind of adding a little bit of weight to the wave, the wave of popular opinion?
It didn't add to the wave. It created a tsunami.
Well, yeah, here's a big shove. Wave, everybody change your mind.
Right, but I mean, let's take another issue, and that would be the issue of gun rights and the two cases, Heller, D.C. v. Heller, and
McDonald, right?
McDonald v.
portrayed as an
Chicago.
Originalist decision, which I contend is more retroactivist decision than.
Is retroactive? I think I need that term defined a little better. Is retroactivist
Originalism used as a cover for activism?
As a cover for bad activism, right? I mean, this is
activism
just
in any way, shape, or form.
Okay, so I'm not quite sure what's retro about that, but we'll go with. I mean, here's the thing. In D.C. v. Heller, you've got a very strong historical argument that, in fact, when the Second Amendment's put in the Constitution, it is intended to keep the federal government from disarming people in various states. And that the right of the people, as used elsewhere in the Constitution, always means individual rights. Is there anything wrong with that? I mean, I don't think it's quite an originalist view, because I think it's based in a very broad picture of what law and rights were at the time it's put into the Constitution. Is there anything wrong with that?
It relies extensively on natural law,
Yeah.
which natural law is not written law. It's discovered law, which was the essence of our law, obviously, for quite a while, up until we started this idea of, let's rely on the legislature for this sort of thing. So natural law is discovered law that you just that's just how it should be. It's just, that's the way it should be. So self-defense is the essence that Scalia relied on for the Heller opinion.
Right.
But it seemed to kind of just declare surplusage the initial language of the Second Amendment when it talks about the militia involvement and everything. So it seems like it's married up to the militia, but then we just ignore it because it's self-defense.
Well, yeah, but I mean, he points out this is again a textualist argument. If I say Brian Bengs being a decent person, I now give my entire estate to him. That'd be $3.48.
It's more than I'm paying for.
The first part of that doesn't, the grant of my money to you doesn't change if you disagree with the first part of that statement. It explains why I'm giving you my money, but it has no effect on the operation of the thing. And there is a reason, I suspect, why in the militia part is in there, because they wanted to explicitly keep the federal government from interfering with state militias or forbidding states to have militias. Much of the same thing is true, I suspect, with the Establishment Clause, where at least part of that purpose of the Establishment Clause was to keep the federal government from monkeying around with religious establishments in the various states. But it does seem to me you've got a pretty strong case that if the Second Amendment doesn't protect a person's right to keep and bear arms, what does it do? I mean, why is it in the Constitution in the first place? Surely there's at least as strong an argument that the Second Amendment protects guns as there is the Ninth Amendment protects abortion or something else.
Well, to the extent that, pragmatism would look at what is the purpose? What is the purpose of this? Why do we have this? And in the Second Amendment, they've explicitly gone to the trouble of saying, hey, the purpose we have this is for you to be able to, jump in and get involved in the militia. It doesn't say, hey, everybody has a right to bear arms, period. It says, the militia. So they've gone to the trouble of explicitly stating the purpose, which marries it up. Your purpose in giving me $3 and how much was it?
48 cents.
48
cents. Okay.
Yes.
Well, it's. I wish it was 50 cents because
then to be rounded off.
Yeah. But $3.48. Your purpose in giving me that would be because I'm a decent person.
Right.
Well, some would say outstanding person.
Some would say
you
that.
would say that.
No one in this room, but some.
Okay.
Yeah.
Well, I just wrote it into my will. So.
So
This is not a legal contract, by the way.
So I'm owed $3.48.
Yeah. Well, but right. I mean, it does identify the purpose, but I don't see how that changes the grant. Somebody who thought that I was wrong about you, I mean, if a judge decides that in fact you're a butt, that doesn't give him grounds to suddenly decide that the right isn't there. Yeah, I mean, now you.
Well, there's a doctrine. Forgive me for going lawyer here.
Yeah.
In international law, there's a doctrine, rebus sic stantibus. The circumstances have changed. So
right.
You can get out of a treaty between states, sovereign entities. They enter into a treaty. Let's say that they enter into a treaty to build a dam because we want to have power.
How about to limit intermediate nuclear weapons? That's one that's in the news.
That circumstances happen. It's a different situation. Let's go with the dam.
Okay, all right,
So,
maybe. All right. I shouldn't interrupt the international lawyer when he's
To
talking
build our
international law.
hydroelectric power generating dam, we need one thing we can't do without. What is that?
Water.
We need a river, don't we? We need some flowing water. So let's say that we're starting to build this and we're a few years in, and then all of a sudden we don't have water anymore. But we still have this treaty. Is the treaty now null? Can we just say, well, there's no point in finishing this because the purpose of the treaty was to generate power. So rebus sic stantibus would say, all right, treaty, you can be absolved. Even if one side says, no, just keep building it because you're using our contractors and so they need the work. So we can dissolve this treaty because the purpose of power generation doesn't exist. So the purpose that we've gone to the trouble of stating the Second Amendment is, well, we want to have the state militia. We want to have this ability. We've just read it out now.
I find this conversation interesting because it's a textualist argument. What you're doing is you're arguing over the text. Yeah. And it reminded me of one of my all-time favorite Supreme Court cases. What strikes me as kind of a model as to how these things should work. Is Lee versus Weissman, which is an Establishment Clause case where what you get is dueling opinions between Justice Souter and Justice Scalia to see who can write a better history of religion and prayer at the time of the American founding. And what's good about that, no matter what side you fall on, and I realize no one watching cares about Lee versus Weissman, but it's about whether you can have a prayer at the end of a graduation ceremony at a public school. And the Supreme Court said, no, you can't have it. But what's edifying about that sort of discussion, even in the discussion you guys are having, is precisely there's a limiting principle here. It's unlike when you think of kind of famous or infamous activist case like Roe. If you read the majority decision Roe by Harry Blackmun, it really is an awfully crafted opinion. It's a bunch of bad science coupled with sophomoric philosophy. And I happen to agree with Justice Scalia in his dissent in Obergefell. If I had written that majority opinion in Obergefell, I'd put a bag over my head. That's how bad it is. It's not even an attempt to articulate a jurisprudential argument. It's a bunch of sophomoric philosophizing, and he's this close to writing romantic couplets, Justice Kennedy. It's emotivism. It's emotivism, and it's bad philosophy that Professor Blanchard would give a C- in Intro to Philosophy. He would have been on better. Make a legal argument. So a case like DC versus Heller, or I'm using Lee versus Weissman, what's fun about those cases is you have people making historical legal arguments instead of pulling Bush League philosophy out of a certain bodily orifice. And those are better decisions.
A certain power that B suggested that we need to wrap it up. Over your shoulder.
Is that what he was saying while I was making that incredibly cogent point?
I believe so. It does seem. I think we should give Brian the last word here, but we agree on more, as I suggested at the beginning, than we disagree on. I think the question perhaps is how we maintain the authority of the court, which it does seem to me is rooted in the idea that the Constitution is a set of rules that are binding on the people, on the legislature, on the president, and on the court itself. And I suppose, in 2 seconds or less, maybe you can tell us, how do we preserve that notion of the authority of the court?
Well, short of a constitutional amendment, the notion will be preserved. The legitimacy of the court will be the big issue, with the discussion of court packing and everything. The essence of legislative compromise, I think, if the legislature divests itself of the extreme partisanship and saying, absolutely not and absolutely so, then if the legislature starts functioning as originally envisioned, the legitimacy of the court will come back, because the court is not then placed in the function of the legislature to answer the questions the legislature should be answering, but is punting to the court.
I think you just said I think you just said we're doomed, but
that's sadly what I think too.
Yeah.
That might be the case.
Maybe that can be the next time we have Brian, and then we can figure out how do we solve the problem with our legislature. I have lots of ideas on that, none of which involve gasoline in a match, which is what other people think. But anyhow, we thank Brian for coming here. I think it was a good, in fact, so good a discussion, they had to tell us to shut up. That's how good the discussion was, is we're talking too much, which is a problem we have. If there's anything in this discussion which has piqued your interest or just made you blindingly angry, you can always email us at spotlight, spelled like it sounds, spotlight @northern.edu. So spotlight@northern.edu. So go ahead and do that if you care to. Otherwise, thank Ken for being here, Brian for being here, and we will see you next time for the next edition of Spotlight.